Good afternoon, everyone. I, Dr. Dhruv, Law Faculty at Mary Professional and Law Institute, going to deliver in the topic that pivotal to the invention in the digital age, that is patent. Specifically, we will explore how patent have evolved in response to the challenge and opportunities presented by the internet era in the related to cyber world. Understanding the patent, let's start with the basics. Patents are legal protections granted to the inventors of new patents and processes. They have provided exclusive rights to the inventor for a limited period, typically 20 years, in exchange of disclosing their inventions to the public. The impact of internet on invention. The internet has commanded how we innovate and collaborate. It has accelerated the phase of innovation, facilitated global communications, and lowered the barriers to entry for investors and the entrepreneurs. Challenge faced by the patent system in the internet era. Despite its benefits, the internet has posed several challenges to the traditional patent system. Now, the global research. Investors now face the challenge of the obtaining patent in the multiple jurisdictions to protect their inventions globally. The second challenge, speed of innovation. The rapid phase of technological advancement means that inventions can become obsolete quickly, making the 20-year patent term sometimes too long. The third challenge, that is digital technologies. Patent now cover digital technologies, software and algorithms, area where the boundaries of patent are constantly being tested. The fourth one, responses and the adaptation in the patent law. To address these challenges, patent systems worldwide have evolved. Now, the international corporations, initiatives like the Patent Corporation treaties and the European Patent Conventions facilitate the process of obtaining patent internationally. Specialized court. Some countries have established specialized patent courts just to handle the complex cases involving digital technologies in their areas. Patent criteria. Courts and patent offices have refined the criteria for their patentability, specifically for their softwares and the business methods to strike a balance between fostering innovations and preventing overbroad patent. Post grant review, that is about the procedures like post grant reviews and their parties reviews have introduced to provide consumers resolutions to patent disputes. Now, the emerging trends in the patenting. Looking forward, several trends have shaping the future of the patent in the internet era. These are, as we know about the artificial intelligence, the role of AI in innovation raises questions about entrepreneurship and the ownership of AI generated innovations. Now, the second is open innovative collaboration. It platform sources initiatives challenge traditional notions of patent exclusively. The third one is blockchain and the IP protections. Technologies like blockchain now offer new way to manage and protect intellectual property rights. Now, if we will conclude about the patent in the internet era, so these are not just about the protecting inventions but also about adapting to rapidly changes technological landscapes. So as we navigate these challenges and opportunities, it's crucial to strike a balance that encourages innovations while ensuring the fair and equitable access to the technologies. Now, certainly, we have some key points regarding the international conventions in which our patents are being formed. Conventions, which are as the first one is a Patent Corporation Treaties, that is also known as the PCT. It facilitates the process of filing patent applicability internationally. It has over 150 countries and parties to this. It simplifies the process by allowing a single international applications that can be pursued in multiple member countries. The second convention which is based upon it, the Paris Convention, It is for the protection of industrial property. It established in 1883. It harmonizes patent laws among members countries. The priority of it allows an applicant to claim priority based on an earlier applications in another member country. It nearly has 180 countries which is a member of this Paris Convention. Now, the third convention is European Patent Convention. The purpose of it is a unified patent system for European countries. It has 38 European countries. The benefit of this treaty was the application process through the European Patent Office, leading to a legal and the single patent valid in multiple member states. Now, the fourth patent, World Technology Property Organization, which is also known as WIPO. It's specialized agency of the United Nations responsible for promoting intellectual property right. The functions of it is it administers the international treaties such as the PCT and provides several for the international protection of patent. It's located in Geneva, which is in Switzerland. Now, the fifth one treaty which is based upon patent is Madrid system, international registration of mark. It though focuses on trademarks, but it simplifies a similar system to the PCT for the patent. It simplifies the process of registering trademarks internationally through a single application. Now, the sixth one, which is the very important, that is TIPS, trade related aspect of intellectual property rights. It is a part of the World Trade Organization, which is also known as the WTO. Agreement sets minimum standard for intellectual property protections. The impact of it is it encourages members countries to establish patent system that comply with the global standard, fostering international trade and innovations. Now, about the implementation, the challenges and harmonized efforts, it differences international laws. Despite the international conventions, it differences in national patent law and practice can complicate international patent protections. Now, it also harmonizes patent and continued with the efforts to harmonize the patent law globally, aim to reduce these challenges and promote the fair and efficient international patent protections. So these are few international conventions which play a crucial role to facilitating the global patent protection, encouraging innovations and promoting economic development by providing a framework for the harmonization of the patent law and the procedures across the countries. Now, if we will look about the Patent Act 1972 in relation to the cyber world, primarily focus on provisions related to inventions and patentabilities in context of the digital technology, software and internet related innovations. Now, here are some objectives or the provisions consideration to this. If we are talking about the invention, so this act defines the invention broadly as new product or processes that involves an initiative steps is capable of industrial application. This definition includes inventions related to software and digital technologies. Patentable subject matter, if we are talking about it, so the act allows the patenting of software as long as it meets the criteria of novelty, initiative step and industrial applicability. Algorithm and the computer programs are considered patentable if they provide a technical effect and are not mere abstract ideas. Now, the business method, innovative related to the business method, especially those involving technical innovations or technical efforts, are also patentable under this act. Now, the exclusion from the patentability, this act excludes certain subject matters from the patentability, include inventions that are frivolous or contrary to the public order or morality. This provision applies to the digital technologies as well, ensuring that the patent are granted only for inventions that contribute to the technical process, novelty and the prior art. This act requires that an invention must be novel and not anticipated by a prior publication or public use anywhere in the world. This requirement applies to digital innovations, and prior act include digital publications and disclosure on the internet. Now, innovative steps. An invention must also involve an initiative step that is not obvious to the person skilled in the relevant art but also in the context of digital technologies. This criteria evaluate whether the invention represent a non-obvious improvement or solution to the technical problem. Now, the industrial applicability. This invention must be capable of industrial application, meaning it must be capable of being made or used in an industry. So this criteria ensures that the patent granted for the digital technologies are applicable and useful in practical context. Now the post-trade opposition and the revocation. So this act, which is the Patent Act 1970, also provides post-grant oppositions and revocation procedures, allowing interested patent to challenge the validity of a granted patent, including those related to digital technologies, if they believe it does not meet the statutory requirements. Now, the last is the infringement and the remedies available under this act. So, this act outlines the provisions related to patent infringement and remedies for the infringement, which apply to digital inventions and technologies. It also provides mechanisms for enforcing patent rights in the cyber world against unauthorized use or reproduction of patented inventions. So certainly again there are few notable patent related cyber law cases that help out the shaping of patent law under cyber world. Now, the first is Allies Corporation versus CLC Bank International. It is a case of 2014. The issue in this case was whether computer related implementation invention, specially related to financial transactions, are eligible for patent protection under US. So, in the present case, it was held by the US Supreme Court that merely implementing an abstract idea on a computer does not qualify as patentable subject matter unless the invention provides something significantly more than the abstract idea itself. This decision has had a significant impact on patentability criteria for software and business method in the US. The another important case regarding the patent is Belinsky versus Capos. The issue in this case was that whether a business method for managing consumption risk in commodity trading is patentable subject matter under US law or not. So in this case also the Supreme Court of US ruled out that abstract ideas are not patentable unless they involved a transformation of the particular article into a different state or thing. This case further clarify also the boundary of the patentable subject matter, particularly of the business method and the software. So these are few keywords regarding the patent under the cyber world. We will do further in the next more classes of this session. Thank you.